My name is Ronald Leenes. I'm the chair of this panel. I'm a professor of regulation biotechnology at Tilburg Institute for Law, Technology and Society. I have very diverse interests, so you can see my name on papers about cookies. I've also written about the right to be forgotten, robots, and what have you. But we're here to talk about the right to be forgotten today. And what I want to do first is provide a brief introduction how we got here. So, as many of you will remember, in January 2012, around the CPDP conference, there must be some relation, the Commission released the draft for the General Data Protection Regulation, and within that draft was an Article 17, which was entitled The Right to be Forgotten. And right from the start, that spurred a lot of discussion. Maybe it was the title of the provision, maybe it was the content, but many people also in this audience were focused on discussing what was actually going on here. And then in 2013, something, well, maybe surprising to some happened, is that what is known as the Google Spain case, and you can look up the official title, the correct title in the program, was sent to the European the Court of Justice of the European Union, the court, and in June 2013, the opinion of the Advocate General Jaume was published, and to me that was a very surprising opinion. And basically what Jaume wrote was Google Spain doesn't fall within the territorial scope of the directive. Second, Google search is not a controller, but rather a passive intermediary. And the third one is there is no right to be forgotten to be read in the existing directive, so Directive 95/46. Okay, my assessment of that ruling, and that's my own opinion, is that the Advocate General considers the directive outdated, and he tries to argue a way forward in a way that, in my opinion, has no ground in the directive. So I was actually not entirely pleased with his opinion. And then we went on, did our thing about the right to be forgotten as framed in the General Data Protection Regulation. And then in May 2014, the court came with their actual ruling, with their final ruling in this case. And in view of Jauskinen's opinion, the court's ruling was quite extraordinary or quite surprising. But on the other hand, from the perspective of applying the directive, the outcome was not surprising at all. In fact, in my view, the court gave the model answer to the questions posed. But again, that's my opinion. The ruling is clear. Of course, there is ambiguity in the sense of how to implement this, but the ruling is also fairly reasonable in my view. Okay, so what is the actual ruling? Well, basically, it's the opposite of what Jaume said. So the Google search operation in Spain is within the territorial scope of the directive. Hence, the directive applies, given that we're processing personal data here. Secondly, Google search is to be seen as a controller. So hence, they have an active role rather than a passive role, as Jaume said. And thirdly, and that is important for now, the result of being designated a controller means that all obligations of the directive apply. So we're not talking future law here, we're talking the current existing directive. And among those obligations, to only process personal data that is accurate, relevant, and non-excessive, and of course then also to honor the rights that data subjects have under the directive. And that includes basically a right to be delisted from search results in Google's search results. Now, the decision of the court made the debate about the right to be forgotten much more tangible. I mean, there had to be taken immediate action by Google. We knew what this was about, and so a lot happened. But also, there were very mixed responses to the whole thing. Obviously, Google wasn't pleased by the ruling, but also media organizations like the BBC Guardian expressed severe doubts, what have you, regarding the ruling. And there were things like, this is the end of the internet as we know it, or EU strikes a blow for privacy. That was in USA Today, for instance. And but also esteemed scholars like Jonathan Zittrain wrote opinion pieces like saying, don't force Google to forget. Now I was looking for quotes to spice up this thing a little bit. And this morning I went to USA Today. I looked for the right to be forgotten, plenty of entries there. But what is interesting is that there is also an ad on this page. And if you look carefully, this is an ad for a right to be forgotten implementing organization. So this is a reputation management company called reputation.com, and Google advertises for these people. So as long as you pay Google, you have a right to be forgotten to be implemented by commercial companies. Now, okay, given the reactions that I saw over the past year, I thought, well, maybe I felt a bit attacked by all sorts of things. I was pleased with the, let me be clear about that, I was pleased with the court's ruling, and I thought, well, maybe this is a European thing, and maybe the rest of the world doesn't like it, judging from the headlines that I saw. So that raised a question for this panel. Is this really a European thing? And you can go two ways here. Maybe this is not a European thing at all, it's just me and a couple of other people that think this is a good idea. So is this something that lives within Europe? And the other question is, what does the rest of the world feel about this? So we decided to host a panel with speakers from various parts in the world and to exchange ideas about this, and also involve heavily the audience in the room, because we have many more nationalities present down here in the panel. Now, before I introduce the panel, one more thing. Let's also place this whole thing of this, and let's not call it right to be forgotten, because that's actually a different thing. We're talking about delisting search results, right? Let's place it a bit in perspective. Now, in the last year, less than a year, 29th May of 2014, Google implemented the mechanism to handle this. Up until the 20th, so a couple of days ago, they received 200,000, somewhat over 200,000 requests pertaining to 730,000 URLs, of which 40% were removed on request by the data subjects. Now let's compare and contrast that to the notice and takedown orders that Google receives regarding copyright infringements. This is a graph showing the requests for removal per week, and that is of course hard to read, but in December 2014 they received 35 million takedown requests. To sum it up for the entire year, that's 345 million requests. Compare that to the 200,000 regarding the right to be forgotten. So maybe that places things a bit in perspective. Okay, now on to the panel. We will have Anna Fielder, who's from Privacy International. Many people will know her. She's a regular here and quite well known. She will act as the moderator. And then we have our esteemed panelists at the other end there. And I start in the middle because that will be the order of speakers. In the middle we have Artemi Rallo, and he's a professor at constitutional law at Jaume I University in Spain, and he's the former director of the Spanish Data Protection Agency, and has relations, or has been in many other institutes both in Europe and in Latin America. So he knows about the European case, but also about Latin America, and he has written a book about the Google versus Spain case, the Google Spain case. Okay. On your right of Artemi, we have Dr. Hiroshi Miyashita. Apologies for my Japanese is really bad. He is an associate professor of law at Chuo University in Japan, and he was the first privacy officer for international relations in the cabinet office of various Japanese governments. He's also, he's all over the place. So he has extensive experience in Japanese delegations for the OECD, APEC, APA, and Privacy Commissioners meetings. And he will talk about that a little bit. And then finally on the left, we have Marc Rotenberg, who hardly needs any introduction, but he is the president and executive director of EPIC. and he's a graduate of Harvard College and Stanford Law School, and teaches privacy and open government at Georgetown University Law Center. And of course, Marc is also all over the place and has a lot to say about the right to be forgotten in this case. So what we'll do is we'll kick off with the three panelists for a brief opening statement, and then involve also the audience as soon as we can. So we really want to have this exchange. Okay, with that, now we get in complicated logistics because I have to move the cable to the other side, but maybe Artemi can start.
Thank you, Ronald. Thank you very much. I am in charge to present the Google case, the origin and evolution, and in some few minutes, no more than 10, to try to offer you some cases of the Spanish experience and summarize a little bit key questions about the grounds of these resolutions. The story of the right to be forgotten in Spain started in 2007. We had a first case. You can see here the main framework where it was conflictive, the question of the right to be forgotten in Spain, was in data on official gazettes and digitized newspaper. Both domains were the main conflictive. Why? Because, as you will see in this and other slides, there are many laws in Spain which made mandatory to publish in the official gazettes personal data. For example, as in this case, notifying administrative resolutions if they are not able to be notified in the mail address to the citizens. There are plenty of, you can imagine, situations of administrative resolution who had to be notified to people. This case, it was a very simple case. A man in the 80s, 18, 20 years old, was fined by local police for an administrative reason, urinating in public street. But no one was able, the municipality was not able to notify the resolution personally in the mail address, and that was published in the official gazette. In 2007, he has become a professor, director of a high school, where students every year, as you can imagine, access to Google to know who is his new professor, and the first thing he can read is that he was urinating in the 80s in the public streets. Maybe it's a funny case. It was the first case. I don't know if it's the best leading case, but for me it's a very important case because it shows that how sometimes we can have hand about, we can feel that it's a funny case, but what is clear is that for this man, it was not a funny story to have published this data. Why? Because the official gazette in the 80s, of course, were not on the internet, but as in so many cases more, all these papers has been digitized. More or less the same in this case. In Spain, it's mandatory to be published in the official gazette pardons, all pardons. That means that in this case, a royal decree pardoned someone in 1999 was published in the official gazette, which was information that this man was sentenced in 92 to 2 years in prison and fined with 1 million pesetas for this time, and that the pardon was conditioned to follow and not abandon medical treatment, drug addiction, rehabilitation. And of course, these men and other Moors, which always prefer not to be pardoned if they could know that the pardon would have been published on the internet with all this kind of information. In this case, like the first one, the Spanish agency urged Google to take necessary measures to delisting and avoid future access to the data. Obliging, which is important, the official gazette to take the necessary measures to avoid future data indexing by Google. That means using robots.txt. Next case, more or less in a similar way, administrative sanctions to civil servants are mandatory to be published in the official gazette once more. In this case, a prison officer was sanctioned, but what happened? That at these times, in 90s, prison officers were in Spain target of terrorist attacks by ETA. He felt endangered and asked for, as a personal motivation, to be delisted, and the agency accept too. Moving to cases about digitized newspaper, I will share this case with you. In 1989, a man killed his son, a 4-year-old child, by pressing a pillow against his face while sleeping in October 1987. This news appears, the fact appears in the newspaper, in La Vanguardia, main Catalan newspaper. This man was finally acquitted of crime of parricide because the trial considered that he suffered a paranoid schizophrenia. The newspaper never informed about this point, and this man in 2010, that means 20 years later, considered that any time someone is able to access to Google, that provoke more illness for him, mental illness, and all that. The Spanish agency, of course, adopted the same criteria, urged Google to take the list and to avoid future access. But being a media, the criteria of the Spanish agency was to consider freedom of expression prevailed, and recommending the newspaper to use technical measures in the case that the media considered that there are legitimate interests based on private individual motivations, recommend the media to use technical measures like robots.txt to avoid the indexation of this news by search engines. And this is the criteria that the agency repeat in all the cases related to media, like in this one, or even this one, always related about, in this case, a case of a crime, a man who in 91 in El País informed about a crime of a plastic surgeon who finally was acquitted. The last case I will refer is the case who was appealed into the Court of Justice. I don't know if it's the best. I criticize that the National Spanish Court has elected this case. You know, before this one, there were more or less 150 cases, all of them different but similar, and the Spanish court decided to lodge into the Court of Justice this preliminary ruling based on this case. In this case, personal, is of course related to personal information in a digital media, La Vanguardia, but not referred to specifically news that were personal information obliged to be public by a public body, the Social Security in Barcelona, related to a private person, in which situation A man, the newspaper website published the information related to an auction of real estate caused by a freezing order derived from debts to Social Security. The public body, the Social Security, tried to strengthen publicity for selling this building. That was the public interest, to increase this kind of publicity. And in this case, the Spain accepted and ordered Google the same. Then what is important is taking into account, like main approach, is that the Spanish approach was not a proactive approach, trying to surveillance about all data. It was just a very reactive approach, based just only in the most of the situations on the right to object, obliging the data subject to justify a personal situation to be grant with this data. If I had in 2 minutes more to summarize the grounds of the position of the Spanish agency or Google, is really very easy, because the grounds of Google are all of them in the Advocate General conclusions. I think that Google never could find better advocate with these grounds. And the grounds of the Spanish agency are all of them fully accepted in the European Court. That means that in both cases, you know, the Advocate General and the European Court have declared applicable the European law. And in both cases, they are considered that Google process data. And the differences start talking about responsibility. General Advocate say that the only responsibility is for webmasters, and the European Court said that there are two different responsibilities. Google has a direct responsibility, as in the case the webmaster has another responsibility. The General Advocate never considered that there was really a right of data protection in the case. He refers to subjective preferences in his position. And the main difference for me, and I hope to talk later enough about with you, is the different approach to the consideration of the data right by the Advocate General and the Court of Justice. For the Advocate General, the directive is to protect too much citizens, needs to be limited, and even say that the right in the Charter of Fundamental Rights is just a reproduction of the directive. Then the main ground is the directive. Didn't took into a real big consideration this right like a fundamental right, but in the opposite, the European judgment take a really good, in my opinion, approach to the data protection like a fundamental right. Thanks.
Thank you, Artemi. Let's switch to a Southeast Asian perspective or Asian Pacific perspective. Hiroshi.
Well, thank you. It's my great honor to be a part of this interesting panel. Well, the right to be forgotten has already arrived in Tokyo from Brussels and Luxembourg. On 9th October last year, the Tokyo District Court admitted injunction of erasing the search result of the Google of the plaintiff who used to belong to the bad violent group. the attorney who filed this lawsuit said, Mr. Kanda, he referred to the logic of the European Court of Justice decision, and the same logic of ECJ was approved by the Tokyo District Court. So the question today is not for and against the right to be forgotten. The question for us today is to how to implement the right to be forgotten in spite of the culture and the social differences on the right to on the right to privacy or the freedom of expressions. When we discuss these kind of issue, we should always, I always use this kind of illustration. We should also take into account the cultural social differences on privacy. For example, Professor Jeffrey Rosen said, the right to oblivion, you know, this is coming from France, but Americans want to be famous, while the French want to be forgotten. So these are the differences. I'm not sure that the Japanese want to be famous or want to be forgotten. I'm not sure. But the clear thing is that spreading the embarrassing personal data online touches on the sensitivity of the privacy in the Japanese as well as other nations, I think. So anyway, we have to bear in mind what we discussed today is the same service for the users all over the world. So the right to be forgotten is not the privilege only for Europeans. The standard of the right to be forgotten should be discussed all the domains, not only for google.coes, but also .com or .cojp. So the question on this right is not just for Europeans, but also for all the users around the globe. So today, let me share my experience about the right to be forgotten in Japan and other Asian countries, also in the APPA, Asia Pacific Privacy Authorities forum. And let me conclude a few words later. So, well, in Japan, if you look at this number, we have already seen the strong demand on the right to be forgotten. If you look at these numbers of the internet injunctions at the Tokyo District Court, the number has jumped almost 20 times during these 5 years, and only in 2013, and only in Tokyo District Court, you can find 274 cases on the request of erasing, deleting the internet contents on the search engines. So it is easy to predict that there are much more numbers last year after the ECJ decisions. So if you look at these graphs, the current lawsuit, these are the current Japanese litigations on the right to be forgotten. We have several judgments so far. One case is now pending on the Japanese highest court, the Supreme Court of Japan. If you look at this Google autocomplete decision, this case was related to the fact that the man's name was automatically suggested by the negative words, which is a criminal history of his past previous records. Well, he filed a lawsuit, and the Tokyo District Court admitted his claim and ordered injunction on displaying the result of search engines. Also awarded a compensation 300,000 Japanese yen, which is amount nearly 2,000 euro for him. But the Court of Appeal reversed the decision. So now the case is pending in the highest court, Supreme Court of Japan. But there are divisiveness of other cases. If you look at the Yahoo search engine case, this case is a very interesting case. The case is about the criminal facts of the plaintiff who took peeping photos and with his small cameras in his sandals. He sued Yahoo Japan after 1 year of his arrest. But the Kyoto District Court rejected his claim because of the short time of passage, just 1 year before history. So it's a relatively new issue. Also, this is a very special social interest matter. So that's why the Kyoto District Court rejected. So these are the Japanese developments about the right to be forgotten. If I share one of the most interesting case, which I mentioned in the beginning, October 9th last year, the Tokyo District Court said, spreading the spreading the negative, embarrassing words in the search engines infringes the data subject right to personality. And Google is regarded as a controller of the website. So the judgment admitted the deletion of the relevant 122 words out of 237 search results. So these are the same logic of the Miyashita judgment, I think. And I would also like to draw your attention about what has happened in the Asia-Pacific regions. We discussed the right to be forgotten in June in Seoul, in December in Vancouver. We invited Google Council in this meeting, and the council said 90% of the requests, Ronald just mentioned about it's a huge number of requests, but 90% of the requests are easy yes or easy no. Only 10% of the requests are hard cases. So the number should not be exaggerated. Also, we, upper member, publicized our attitude, saying that this issue remains flex, and the forum is committed to continue to closely examine the right to be forgotten, its applicability, and its member economies. So we just started this discussion in Asia-Pacific regions, and for example, in Hong Kong Commissioner, my friend Arlan Chang wrote in his official blog, said that there is a possibility of further collective action, joint action, is not ruled out. In my perspective, Asia-Pacific region, privacy authorities look in the same directions, and I think the further communication and further collaboration with European countries are expected for joint action in the near future. Well, I'm not in the best position to share about the other jurisdictions in Asian countries, but to my best knowledge, I can share a little bit about the other jurisdictions. For example, in Hong Kong, if you look at the official blog, Google is not regarded as data controller. Google has been regarded as intermediary in Hong Kong in their judicial judgment. In Korea, I hear from the commissioner's office, they are now discussing about the legislation on the right to be forgotten. I also hear that there are already several academic articles on the right to be forgotten in Korea. In Singapore, they have been discussing this kind of issue, but their law cannot extend to the Google where the data center is located outside their jurisdiction. In Thailand, where the data protection law is now being drafted, I asked my friend in the Prime Minister's office, they said that they don't have a serious claims so far, but they carefully observe the EU movements on this matter. But anyway, Europe already took the initiative on the right to be forgotten, but the jurisdiction in Asian countries carefully observe what has happened in the EU, so these are the Asian situations. Well, let me say a few words about the logic of the right to be forgotten. Well, it's a very complicated logic. The logic of Miyashita judgment is to affirm illegal publication for the legal contents in the search engines. I think this is a relatively tough question for the lawyers. Of course, there are some mild and fierce, not fierce critics in Japan based on this logic. But if I attempt to reply these tough questions, I can make some arguments. Maybe the first one is a typical European logic. Well, data subject is always subject, not the object of the computer. So the data subject is the author of his or her life, not the interfered or harassed by the computers. The second argument I can add is that controlling data is a kind of a controlling time. I would like to draw your attention that the opinion of Advocate General of Data Retention Directive, not the right to be forgotten opinion. In December 2013, Advocate General already wrote, if the principle of retaining all their personal documents for a certain period of time is considered lawful, it remains to ask whether it is inevitable for it to be imposed on individuals over a period which covers not only the present time, but also a historical time. So time here means time for present and past, and both shape ourselves so that controlling time should be an element of data protection of the right to be forgotten. Well, I can skip this slide, but I just would like to mention about the Japanese movements. We have Yahoo Japan set an expert team of setting a standard of deletion in last November. So I think Yahoo Japan is obviously waiting for the report by the Google, which is supposed to be publicized in this month. Well, this is crucially important because, you know, it is nonsense that you can search a certain contents in .es domain, but you can find some contents in .com domain. It is nonsense. It is also nonsense that you cannot find a certain content in Google, but you can find something in Yahoo. It is nonsense. So our global task is how to streamline the global standard of different domains for the different search engine companies. Well, these are the questions, I think.
Okay, thank you. Then I'd like to give the floor to Marc Rotenberg. And have I got no news for you? Your slides are available. So if you want to show the images, then I can if the cable comes back to my machine. Just give me a signal when you put one.
I thought they might have been forgotten.
Oh, no, I don't forget. I don't forget.
I have that right, yes?
I have a delete button here.
At least in the .eu domain, I have that right. Okay. So let me just begin by thanking Ronald for organizing this panel, and also Tilt, who invited me to speak this week. I gave a lecture on this talk. I gave an American perspective on the right to be forgotten that I think surprised people. I'm not going to repeat everything I said during that lecture. I want to provide some new information because I also see people who were here earlier in the week and make this talk worthwhile for you. And to say as well, there's a great deal of material from EPIC about the right to be forgotten available on the internet, and you can find it simply by searching EPIC Right to be Forgotten. It begins actually when the opinion was announced. I remember it quite well. I was pleased and not particularly surprised. I expected the court to reach that decision. I was familiar with the opinion of the Advocate General. I didn't find it very persuasive. There was just a few months before the decision on the Data Retention Directive, which was, of course, good news. And a month afterward, there was the decision from the U.S. Supreme Court in a case that we were involved with concerning the searches of cell phones, Riley versus California, which was also a very good decision in terms of an affirmation of a fundamental right to privacy. So frankly, it was a good year for a privacy advocate. I was quite happy about how things were going. And USA Today contacted me, and they said, well, you know, we're going to do an editorial, and we're going to raise some concerns about the opinion. We actually think it was not a good decision, and would you like to write an opposing editorial? I said, I'd be happy to write an opposing editorial, which I did, and you can find it online. And I basically said the decision was not surprising. In fact, I said not only the outcome, but even the analysis looked very familiar to me. I said it could have been written by Justice Louis Brandeis. It followed almost directly from the right to privacy article, the famous article from 1890, which I've taught for the last 25 years at Georgetown. I said this is, you know, essentially what Brandeis was describing, articulating a right that people have in the collection use of personal data held by others. But here's the more remarkable part of the article, because of course you know that, that's the simple summary. Having announced the right to privacy, the very next thing that Brandeis does in the same article is to ask the question, well, what is the competing interest? And he says, well, of course, the competing interest is the public's right to know. The public does have a right of access to information, and we need to think seriously and critically about how these two rights interact. And with regard to some category of people, for example, public officials or people in public life who say that they value family values but have a private life that's hypocritical or contradictory, maybe their private life becomes relevant. But for people who are private in their lives, maybe their private lives is not a matter for the public to know about. And you see, all of this had been considered by Brandeis more than a century ago, and it's essentially reflected in the analysis where not freedom of expression is pitted against the right to privacy, but rather access to information, which we all agree is a very important right. Brandeis did. He understood it. In fact, Brandeis was not only the cornerstone, the architect of the right to privacy in America. He was a great First Amendment advocate, believed very strongly in freedom of expression. And his defense of war protesters during the First World War also provided the bedrock for the American constitutional First Amendment claims. So I think we can rely on Brandeis not only for his commitment to privacy, but also for his sensitivity as to the right to access and as to free expression. And again, to me, none of this seemed particularly surprising. In many respects, it was a narrow outcome. You know, we're talking about a commercial search provider. We're talking only about taking down links. We're talking about, you know, information still being available. It seemed very straightforward. And if you need empirical data, by the way, I mean, put aside the articles that have been written by a few legal scholars in the United States, very good writers, very passionate, quite brilliant, but just put them aside for a moment and look at, you know, the one response you will get if you search for U.S. attitudes right to be forgotten. It was a survey done by a tech firm not long after the decision came out, asked, you know, I think 500 Americans, what's your view of this? What do you think? 61% of Americans said they agreed. There should be a right to be forgotten. 39% said it should be absolute. 6% said, well, for public officials, maybe we should have a different analysis, which was already taking them down the Brandeis road, which is the correct way to think about this. Half of the people who responded to the survey said that irrelevant information can impact one's reputation, can cause harm, and should not be available online. I mean, all of this strikes me actually as common sense. And not only is it part of our tradition in the United States, not only do we have in every state in the US expungement laws that routinely permit the removal of personal bankruptcy records, like this man in the case, routinely permit the removal of juvenile offender records because, by the way, we've made a social decision that maybe it's not such a good thing if a young person is merely arrested as a teenager for that stigma to follow them through their lives. It can be, for example, socially disproportionate if young African American males who are routinely arrested but never charged, prosecuted, arrested, or incarcerated have that information when they enter the job market. And we allow them to remove it for offense committed as a young person, for an arrest as a young person. I mean, again, this is all straightforward, simple social decisions. As the internet economy has gone forward, and a lot of personal information becomes available online, particularly information of young people, legislators in the United States are not surprisingly concerned. California, a year ago, passed a law called the Eraser Law. It gives, you know, families the right on behalf of their children to remove information from services such as Facebook and Google. It went into force this month in California. It is the law in California, the largest state in the US. So this very odd, you know, well, the right to be forgotten, that's kind of a European thing. US values freedom of expression, that's how the US understands it. There's virtually no support for this. I say this sincerely. I've had two major debates in the US on this issue. I did one on National Public Radio with Stuart Baker, who's the former general counsel of the National Security Agency. We debated, Stuart and I, 20 years ago, key escrow encryption on behalf of the NSA. He was defending the NSA's right to get access to private communications. We were opposed. I think we won that debate, although Mr. Snowden proved that we lost the war. Okay, I'm sorry about that. But more recently, Mr. Baker is arguing, you know, against the right to be forgotten. In his line of work, I understand that. But when we did this national radio program, everybody who called in said, you know, what can I do? How do I have this information taken down? I try to get a job. I try to do these other things. And people go to Google and they find something embarrassing about me that's not relevant and shouldn't be there. Virtually every call we received was of this type. I did a debate with Jonathan Zittrain in US News and World Report. Great internet policy expert, no criticism of his knowledge. But when it came to this issue, just about everyone who cast a vote, well, I won't say just about everyone, but let me just say I won the debate soundly on the issue of the right to be forgotten because it was intuitive to people. They should have this right. Okay, I'm going to wrap up with just a couple even more radical propositions because I'm not sure if everyone is hearing all of this. Here's my first radical proposition. It is obvious that the judgment of the European Court applies to the .com domain. And I say this not only with a privacy hat on, but also because I was one of the people who founded the .org domain. I was chair of the organization that managed the .org domain. We're very, very strongly committed to having nonprofits, NGOs, and everybody else on the internet work very hard to make that happen. So I know a bit about the TLD system. And it makes no sense whatsoever that a search company that operates search across all of the internet can limit the application of a legal judgment to a narrow jurisdiction. That is the balkanization of the internet, if you want to have that debate. It's when the search company says, oh, we will only apply that rule here. It's the individuals whose personal information is at risk. Google already removes credit record information. If your credit card number, your bank account number is available on the internet, you write to Google, I promise you they will take it down, and not just in your country, for the obvious reason that if your credit card information is available in another jurisdiction, it's accessible and will be used to commit fraud against you. And of course, privacy harms are not just economic harms, and that's also the significance of the decision of the European Court. So this should be extended across all domains in which Google offers search. Otherwise, you do not have an effective remedy for the right that has been announced. So let's just solve that problem. Last point. I think this is a very good decision for free expression and for the future of an independent media. And I've written this, and I believe, I can't guarantee, because there are always things that happen the last moment to change things. I think this essay will appear tomorrow in USA Today, because USA Today has come back. Apparently the report is going to be coming out from the Google expert group. I think USA Today will endorse the report. And so they said to me again, would you please write, you know, I mean, we don't agree with you, of course, but it will be an opposing view, but we'd like to hear your view. And I said, okay, I'd be happy to write. I said, I'm not going to write the same thing I wrote before. I've already explained to you why I think this is American value. So let me give you a new thought. My new thought is that this is good for the press. And it's good for the press for multiple reasons. First of all, and most importantly, the media has become too dependent on Google to make their material available on the internet to internet users. The media is suffering today from Stockholm Syndrome. They are identifying with the interests of their captor rather than seeking their own freedom. And this will not end well. We need a way for independent media on the internet to be accessible without being entirely dependent on whether or not a link is going to come down at Google, their search rankings are going to be lowered, or Google is going to compete with them. Because by the way, if you're in New York City and you type in news, it's not the New York Times that comes up at the top. And if you're in Los Angeles and you type in news, it's not Los Angeles Times. And if you're in Washington, it's not the Washington Post. It's Google News, which has replaced all of those excellent newspapers in the search rankings. This is a very serious issue, and the media knows it. The media knows that they are losing readers and revenue to Google. Now, this is not criticism of Google. Please don't do that. It's too easy to do that. People will say, oh yeah, I heard Marc. He feels very strongly about privacy. He's very critical about Google. But that's not really what this talk has been about. This is an objective analysis of the significance of this decision, what it means for the right to privacy, how in a converged world it's a right we all share, and how vitally important it is for the media to assert its independence at this moment in time.
Well, so it's my time to take over moderation, and I want to thank the panel very, very much for this totally refreshing approach from all sides, which was factual, evidence-based, and well argued on all sides, and also, by the way, learning what other cultures think, although we haven't heard for Latin America. I see some colleagues from Latin America here. So I have two clarifying questions to the panel, and then I'm going to open it up to the audience, and I hope there are some challenging questions too, because you know it's a fairly harmonious panel, as you've seen. So I have this history question. A lot of arguments that have been given to me, particularly in the US, where you know there are a lot of dissenting voices, and by the way, also from well-known privacy advocates that have written blogs saying, oh, you know, the Europeans don't have freedom of expression and we in the US do. Therefore, you know, it's a fundamental difference in values. And it was said yesterday on a panel here by a speaker who said, for example, EU right to be forgotten is at odds with US legal principles and rights. But my question is about history. One example given to me is what happens, for example, in former totalitarian regimes of Eastern Europe or Spain, or indeed in some countries where the governments are turning radical again, or even in the UK, for example, where you have an individual in his private capacity given racist and various other sort of hatred comments 6 years ago and then decides to stand as a candidate for a party that should not be named and asked for his previous remarks of 6 or 7 years ago to be deleted. You know, I mean, that is a strong argument that applies to a lot of countries that maybe don't have such democratic governments. So I'd like a comment on that. And then on this domain issue, I think Google announced last week that it's only going to apply this ruling to the EU domains, which effectively is a partitioning of the internet. So I'd like a little bit more comment on that before we go to the audience. So who would like to start?
Well, the topic of the right to be forgotten, and obviously the reference to the judgment, always is linked to the question of censorship. No, is the big argument, not your big argument. You are making the evil advocate, I understand, because in this case it's the Google argument. Is the main Google argument is that the right to be forgotten is, among other grounds, is against freedom of speech in related to these countries where democracy has problems or dictatorships and all that. I really think that the right to be forgotten in the precise way declared in this judgment has nothing to do with that, with censorship, with I can imagine that in Iran or in any dictatorship country, there will be citizens, private citizens, where their data will have to be protected or not, or their citizens will not have this right, and in the case protecting the right to be forgotten, because the judgment is clear that the listing has a limit, and the limit are public interest information. Public interest in personal information are personal data related to public figures. This is the limit. Then to try to extend the discussion to other things is just part of the confusion strategy that usually is well used by Google.
Well, just one quick comment about democratic principles and erasing history. Well, Marc mentioned the Luis Brandeis. So Luis Brandeis also was a great advocate of free speech in Whitney versus California in 1927. He mentioned men feared witches and burned women. It is not our wisdom that we fear Google and burned search engines. That is absolutely wrong view. So we need Google. We respect the innovation of Google or other search engines. So we need free flow of information. But the question here is just Artemi mentioned. We just want the delist on the website. We still remain the fact somewhere in the website. So I think that is a sense. And also Colin Bennett is here. So Professor Colin Bennett also wrote his article, the quasi forgetting he mentioned. So the listing or not erasing the history, but just the listing should be making sense in the logic of under the ECJ judgment.
Thank you, Marc.
I'll just make a brief comment about a First Amendment analysis. I mean, if we really have a First Amendment discussion, you need to know that the First Amendment doctrine in the U.S. court system distinguishes levels of scrutiny based on the nature of the speech. For example, if it's political speech, it's subject to strict scrutiny, and government regulation is highly suspect. If it's, regulatory commercial speech, there's greater deference given to the legislature in the decision it makes, for example, to require that a warning label be placed on a pack of cigarettes. The court has allowed that, whereas a person cannot be compelled to say something that they don't believe, to take an oath or to make a pledge, because we understand that a person's political speech carries greater weight than the commercial speech of a corporation. This is the kind of real discussion that I think we need to have if we're actually going to talk about how the First Amendment applies to this case, to sort of wave our arms and go, well, of course, free speech has to be balanced against privacy. And by the way, that was not the balance, it was access. But even let's engage in that little game for a moment. Let's pretend it was free speech. In my view, it's actually the speech of the Spanish newspaper that we need to be concerned about, the news entity. That's the type of journalist-based organization that free expression law typically protects. And your agency made the right decision, because Mr. Constanza had gone not only to Google, but also to the Spanish newspaper and said, I want that removed from the website and the archive. And you said no. And that was in a sense, the decision that followed from the European Court. So this was an actual defense of free expression. And if I were a smart lawyer for a media group, rather than one reading the advice from Google, I would say, this decision helps my client, because this distinction draws a distinction between media organizations that are not subject to liability under this ruling and Google, which is subject to liability. Now, I understand Google's opposition. It's rational, sensible, and they're very effective in trying to oppose and undo the decision. But if you are a media-aligned entity, if you are a media lawyer, if you are a journalist, you cite this decision in your support, and you say, under this ruling, our interests are protected.
Okay, thank you. Sorry, I need to open this up to the audience now and look at the show. All right. Sorry? Oh, right. So are there microphones, or there's a microphone in? Okay, so what I'll do, for the front people, I'll do it at the front. For a minute. Can I take it in batches of 3? Sorry, it's like being at the Inquisition here. Can I have it Can I have it in batches of 3, and we'll take it that gentleman there. Can you please state your name, and then can you please keep it brief to give other people a chance? Yeah.
Yeah, Winfried Feil is my name. We're talking about the public interest in information and about the freedom of expression. But I think the discussion lacks the question, who is it who demands the public interest and the freedom of expression? And I think there should be a term which should be brought into the discussion. It's the third party. It's the third party that has no rights in this discussion. We have on the one side the data subject, and we have the controller, which is in this case Google. But and we have the public, and the public has no. We call it. I miss the English term. We call it in Germany the Sachwalter des öffentlichen Interesses. There is no one who speaks for the public, and when it comes to certain examples, there might not only be the public, but also 1, 2, 3, or 4 or 5 third parties that do not even know that what they have said cannot be found anymore. And what I think is there is an imbalance between the right to be forgotten and the right to be found in public. There is no right to be found so far, until now. So you cannot go to the courts and say, I want to be found, my opinion is important, I've said this a week ago, and I want to be found now, still be found.
Yeah, okay, thank you. Please keep it brief, because there are many people that want to speak. All right, the lady at the back, I think, right.
Yes. My name is Magda Piech, and I have a question. What's your opinion on what have been said about the right to be forgotten change if the situation on the search engine market is different, and instead of, let's say, 2 in each country, we would have 5 or 6 that matter? And in particular, I mean, would you still agree with the statement that the search engine is the controller of the data? And second of all is that we can distinguish between the legality, lawfulness of information at the source website and the link in the search engine. Thank you.
Okay, one more question, please. I'll go, yeah, that gentleman in the 3rd row there.
Hi, I'm Javier Ruiz from the Open Rights Group in the UK, and just to throw a couple of the questions, of the harder questions that we faced. One was on, well, what we've been asked is whether we should let Google be the one who decides. So one question would be, what is the process and who's going to make the decision on the balancing? That was quite important. And the other is, how do you then, and what would be the impact of this ruling for the development of digital archives? Do we need a different type of search engine that is only archival? And that sort of thing. And the third was on the role of profiling in building a data controller, and the fact that it wasn't just information, but the collection of information into one coherent whole, and what does it tell us about data brokers and the wider implications for people building open data, aggregators and personal information. So those are the 3 things then.
Okay, thank you very much. So we'll take these 3 questions. Can I please ask the panel not to answer all three of you, because it will take a very long time and we need other people to talk. So the first question was about the right to be found, the third party, which is the public that doesn't have a voice. Who wants to answer that?
Well, I would say that I have to say that I don't agree with your position about the lack of representation of the interest of internet users, no, or public. I don't know. It's difficult. We will be confused about many concepts. In public, internet users, internet activists. One of the sector who has been really against to the right to be forgotten is the internet users activism, and one of the argument is this one. There is the right of any citizens, any internet user, to access to any information on the internet published. Like if the law, the constitution, or other framework establish an obligation for any citizens to support that his information has to be accessible on the internet for any citizens. In the European judgment has resolved this point, telling that internet users has not this right, internet users, to access to any information. It depends, the argument, the ground of the judgment is that all depends on the public interest of this information. Internet users, public, will have the right to access to this information just if there is a public interest. Which is the meaning of the public interest? Just personal public figures, or just facts of public interest? Who decide the public interest? This is the This is the point. And one of the main arguments from Google to apply the judgment is that, oh, sorry, now we have a terrible big power to decide which information will be published or will be deleted or not on the internet. I think, I want to share with you that what happened before, until now, just 1 second, is that Google used this same power in an arbitrary way not to answer any complaint asking for deletion of data. They were using. The only thing is that now they have to provide an answer. If there is no answer, there will be a right of the citizens to appeal to the DPA, and even if the DPA, if the citizen don't like the resolution of the DPA, the resolution could be appealed on the judges.
Okay, thank you. What about the search engines as controllers question? And there was another interesting question there. Would the same judgment apply if you had lots of search engines and competition?
I'll be very brief. I mean, I think the short answer, which of course is the answer in the opinion, is yes. It regulates a sector, an industry, as opposed to a particular company. But I think the key is that it is even more yes when a single firm dominates a sector, as Google does in search in Europe. So that's actually the way to understand the relationship here. It's obvious that you would apply the obligation for all data controllers in the sector. You would apply it even more so where you have a single dominant controller.
Hiroshi, you were saying that Hong Kong decision is that Google is not a controller but is an intermediary. Can you comment on that situation a bit?
Well, that's impossible. Because I don't know the Hong Kong law, but you know, the data controller and data processor distinction is typical European, I mean the data protection regime. And the Japanese law, we don't have such distinctions. So I think the Hong Kong does not have either.
Yeah, no, but if it is an intermediary, then it wouldn't have the same obligation. I mean, I'm just asking the question. Presumably that was the question. Okay, right. So the last question on, is it right for Google to be both the judge and the jury and make the decision? And what about the profiling issue? Who wants to take that?
Well, I have answered a little bit before, but I would like to add one, I think, important point on the judgment related to the right, the Google right to process data. They have the right to process data. They have legitimation to process data, but based just in economic arguments. It's the economic interest of Google, the legitimation criteria, but this economic interest not prevail is under the consideration of a fundamental right like data protection. This is in the judgment.
Okay, thank you. We have time for 2 more questions. Can I, yes, please.
Thank you. Colin Bennett from the University of Victoria in Canada. And just to add to the confusion, the situation in Canada, I've been told, is that Google does not see itself as the controller under our law, under PI.Lab, which is an interesting position because you can read our law as saying that, well, there are in fact certain provisions on data retention, data accuracy, etc., which could effectively give you the same right. Now, the other part of this, of course, is that Canada is an adequate jurisdiction, right? So I think this is probably a question for Artemi. Isn't the logical corollary of all of this, implication of all of this, that under the regulation, something like a right to be forgotten has got to be included as a test of adequacy in the future, so that countries like mine and Hong Kong, etc., might have to amend our laws, and European citizens whose rights have been found in Europe are also seen in Canada and other countries.
Okay, thank you. One more question there, and then Lily, you have the last word.
Yes, Mr. The guy from Spain, Artemi, I think. You said there is, in the case that Google kind of says no, the DPA can kind of, there's an appeal at the DPA, and I simply wondered what is kind of the procedure at the DPA, the Spanish, for example, DPA, in case Google says no.
Well,
okay, so one question from Colin about the transference to the Canadian rights, one about procedure with appeals, and Lily, you have the last question.
Thank you. I wanted to thank the panel and the organizers and the moderator. I think this has been a very fascinating discussion. There is an early decision on a U.S. case when the internet service provider was sued based on the content of a page that was generated or provided by access to another person. Whether the internet service provider was responsible for the content on the page that was generated. There was a law passed that said no, they weren't. A court decision, no, they weren't. Actually, the publisher of the page was. I think that decision is overarching and influencing this debate. I think that if we think about it, it's like the yellow pages. Who publishes that? Who provides access? What the information is that's provided? There has to be some obligation on the side of those who allow and can control the number and the ranking of the information that's provided, and that there is some responsibility. I think globally there has to be some confluence of decision about that responsibility, and I'd love to see further expansion on that.
Okay, so 3 questions. Okay, so Marc, you start with the last, and then Artemi, you have a specific question.
Okay, I'll just jump right in. I mean, I think Lily has asked a great question, and I also think she's right. I mean, what she's pointing to is Section 230 of the Communications Decency Act, the 1996 U.S. law, which established very broad immunity for internet service providers, not only for dissemination in the traditional carrier context, but also for publication. And it resolved 2 cases that went in opposite directions, which I think Lily is referring to as well. One was Cubby versus CompuServe, which found no liability. The other is Stratton Oakmont versus Prodigy, which did find liability. And I remember all this because I was involved in that case as well. We were pleased with the decision, but you know, the odd thing that happened is that as this, you know, immunity plus doctrine has gone across the internet, it has made companies essentially not responsible at all for anything that happens, even as they begin to look less and less like the common carriers that they were 20 years ago. And I actually write about this for USA Today in the essay tomorrow, because what I describe is the internet of 20 years ago. That internet was described by the Supreme Court as a web of interconnected digital libraries, bookstores, and newsstands. No one at the time contemplated that there would be such large dominant firms in the middle. And I think if we had, we would have made a different judgment. I think the law needs to change, but I think, Lily, what you say is correct. I think it is that decision that looms over much of this.
Thank you for that. Artemi.
About the second question, well, all DPA has their own internal procedures for processing the complaints on access, right to erase and others. And of course, this kind of complaints will be processed like the right to erase or the right to object that it's the case. No? But coming back to the first very good point and question, well, the problem is that we have to resolve some points before talking about what are adequacy requirements. For example, how will take into account finally the regulation, the Article 17, the right to be forgotten? Because I think in a very regrettable decision, the European Parliament erased the name of the thing. The name of the thing disappeared of the regulation, not the content. It's curious, no? From the legal point of view, there is the same content, but the name of the thing was erased, no? Why? It was the moment of the conclusions of the general advocate. Of course, there was a strong influence of this, but that has changed. And there is an European Court judgment decisive that I think the European Parliament had to take into account. And in the negotiations, they must recuperate the name of the thing. You know? I think, but another thing is that in any case, even without, even 30 seconds?
15.
Wow. Even without the name of the things, the right to be forgotten under the judgment is in the ADN of the right of erase and the right of object, and that have to be applied. Another thing is how require their adequacy. We will talk later about that.
Yeah. So I would like to thank the panel and also the audience. I mean, I know that many people are really desperate in asking questions and engaging in the discussion, and it would be my choice to have 2 slots for this. Unfortunately, I'm myself booked for another slot, so I have to rush over to Maison des Arts. So please follow me for the academic paper sessions. I'd like to thank the panelists. I'd like to thank Anna and, of course, you. So